This is the proposal that we've seen in the consultation. So the Commission is going to examine. So that's an important word, examine. It seems to me that there's no commitment there. But we're going to examine the following elements, which include appointing an independent data protection officer. So just to set out my conflict straight away. So I'm the president of the National Association of Data Protection Officers. So I have it in my objective to support this august crowd of fantastic people. And secondly, I am Phil Fisher Waterhouse's data protection officer. So there we go. I hope Chris Graham isn't in the room. Now, the way I was looking at this is, to me, the most important thing to do when you're analysing a proposition like this is really to see what failure tells us. That's the beginning of the journey for me. So my practice focuses on the failure end of data protection, and then Eduardo, my partner, does it all the way up to there, if you like. So that's how we work together. So when things go wrong, that's when I start to operate, and of course that takes me into the court environment as well, because I'm a litigator by background. So that kind of mindset always focuses you on the evidence. So what does the evidence tell you? Where does it take you? And does the evidence of failure support this proposition, or does it reject this proposition, or is it somewhere between these 2 points? So I think that's critical, but before we get into a process of law reform, where we propose, on paper at least, fantastic new ideas, we should ask this question. But European Commission, what is the evidence? What's the evidence basis behind this proposal? Because one of my concerns is that we are engaged on a process of law reform, and we're going to build a regulation. It sounds like not a directive, and it's going to look at this. But will we be any better off in 5, 6, 7 or 8 years' time? And it might be the case that the people who are leading this agenda will not be in office then to actually answer whether or not the proposals were fit for purpose and they were going to achieve things. So the evidence basis behind these proposals is absolutely critical in my view. Because without evidence, then there isn't an authoritative basis for anyone to speak. So that's where I'd begin with all of this. So the evidence that I have is evidence acquired post-failure. And the environment of a data controller facing a potential financial penalty at the Information Commissioner's office, or whatever it might be, at that stage, when a case is serious, you discover that you get access to all the evidence. So that you get into places that regulators don't necessarily get, where commentators may not actually get to, and you get to see the nitty-gritty. And to me, when you look at the question, why do organisations fail on data protection? That's got to be the question. Then you see roughly 3 areas, if you like, that you can place all of these causes into. So there's 3 big buckets. Now, these buckets are firstly that there is no ownership of the issue. So that's one I see regularly when you engage with the failing data controller and you ask them the obvious question, well, who was in charge? And they sometimes can't answer that question. So clearly, not having ownership is critical. The second bucket is the absence of a system. What I mean is a set of rules. So an organisation, and if you think about theories of regulatory behaviour and compliance, what happens is a regulation is passed, that sets the behavioural tone for society. You create a set of rules, and then you embed those rules into operations, and that's how compliance flows. So basically, Janet or John on the shop floor, how on earth can they behave in a data protection compliant way if they don't understand what the rules are? So an absence of clarity about rules, the system, is the second bucket of failure in my view.